Please be seated. Call now cause number PD 025721, Danna Presley Sear versus the State of Texas.
Good morning. May it please the court, opposing counsel. I'm John Messinger, Assistant State Prosecuting Attorney on this case out of Gaines County. This is an injury to a child case with two different manners and means. The basic facts are that appellant's husband, Justin, violently shook their 4-month-old daughter on a Saturday evening at 7:30 or 8 o'clock. It was not until 10 or 11 o'clock the next morning that anybody decided to go get medical care. And it wasn't until 18 hours after the violent event that they arrived at Covenant Hospital here in Lubbock, where the child was immediately put into surgery for massive brain swelling to drain that and try to save the child's life. And saving her life was miraculous. The issue at trial was whether or not a concurrent cause instruction should have been given. It was requested, it was denied without much conversation. The Court of Appeals reversed.
Counsel?
Yes.
What is the concurrent causation instruction? What does that entail?
Well, it's section 604A, and it's the definition. I refer to it as instruction. It's not. It's just the law on what establishes causation. And a person is criminally responsible for the result if it would not have happened but for their conduct, either alone or with a concurrent cause, unless the concurrent cause is clearly sufficient to cause the result and what the actor did is clearly insufficient. And so for two different reasons, that instruction is not applicable in this case. The first one is trying to blame what happened on Justin doesn't work with this offense because the first manner and means the state alleged was a failure to protect from Justin. So in a case like this where you're reckless for being aware of and consciously disregarding the risk that Justin would do something like this, the fact that Justin did it doesn't absolve you of the crime. He's guilty for what he did, and in fact, he's been convicted. But that does not mean appellant escapes responsibility. It's no different than if you allowed your toddler around a swimming pool and then blame the swimming pool for the toddler's death. Or if you let your kid play with a tiger and you blame the tiger for doing what tigers do. So as a matter of law, for that first manner and means, there is no room for the applicability of a concurrent cause instruction.
I'm curious if you have an explanation for that 6.04A doesn't say anything about sort of except in cases where liability is based upon an omission. Is there some way, because that's the way I understand your argument, is that basically it comes down to the fact that there's an omission here, and so 6.04 isn't congruent with the law of liability based on omission?
It's not that it's an omission, it's the fact that the nature of injury to a child by omission, when it's based on a parental duty, means that the failure in your parental duty to protect your child from whatever the harm is makes you responsible. And to reconcile the two, you would just look and say, this offense is a more specific application of criminal responsibility than 604A would be.
But you don't disagree that we would, if we were to go with your position on that, we would have to sort of reconcile the law of 6.04A with the theory of liability that was pursued in this case.
Right, and that is how you would do it. You would say that as a matter of law, when you are responsible for an injury because you did not protect your child from that danger, you cannot turn around and blame the danger. Mm-hmm. Now that danger, if it happens to be a person, can also be charged and should also be charged. But the fact is, if appellant was reckless, was aware of this risk, consciously disregarded it, then she should be responsible for what happened. Again, it's no different than if it's an inanimate object that poses an obvious danger. And the evidence is sufficient. I should say, as I pointed out in my brief, that because the way the Court of Appeals settled this, and there were two alternate manners and means that were tried together with a general verdict, they only did the sufficiency of the evidence for failure to seek medical care. They have not addressed the sufficiency of the evidence of recklessness on failure to protect.
But is there any specific part of the language found in 6.04A that you rely upon to suggest to the court that something about 6.04A excludes its applicability in cases like this?
Other than the way it works.
It seems generally applicable, is my point. When you just read it on its face, it seems to be a generally applicable theory of imposing liability, so.
Well, no, it would actually undo the more specific offense of injury to a child. I mean, if you have injury to a child for failure to protect, and what you fail to protect from is a person, then you can never find liability for that. And I mean, again, I think the evidence is legally sufficient. It needs to be decided on remand in order to make my first argument complete. But when that's the case, and I guess I'll go with your hypothetical, not your suggestion necessarily, you would be creating a scenario where if you know somebody's coming up the street looking to stab a child, and they walk right up to your kid and you do nothing, you have no parental responsibility because it's a person as opposed to a wolf or a tiger or a runaway street sweeper. I mean, so the fact that it should be a person, and so a person could also be responsible, doesn't mean that you've not failed in your parental duty. I can't understand it working any other way than that. And to reconcile the two, again, you don't have to go farther than the fact that there is a specific application that is going to control over the general, even though it doesn't explicitly refer back to 604A.
Counsel?
Yes.
You're focusing on the omission, manner, and means. What about the manner and means about failing to seek reasonable medical care? So if the jury happened to focus in on that, then would not 6.04 come into play?
No, it's factually inapplicable in this case. 604A is designed to supplement whatever an ordinary definition of causation would be. And so it's designed to say that when you have multiple causes, as long as you're a but-for cause, we're not going to have a fight over what percentage of the injury was caused by which actor. This isn't a civil case. We're not trying to apportion damages to people. If you're a but-for cause, doesn't matter how many other concurrent causes there may have been, the only way that you get off the hook is if there's some evidence that what you did was clearly insufficient to cause it. And that's an abstract inquiry. And you need evidence for that. And based on the strategy that defense counsel was going for, the questions he asked, while pointed and interesting and serving his theory, don't serve what should be the proper interpretation of 604A. So, for example, he asks Dr. Patterson, is there another primary or independent cause for the child's injury other than Justin? And she says no. And that's true. None of this happens but for what he did, regardless of the failure to protect. So, and when she's asked if she had gotten immediate medical care, would her condition be better? And she says it's possible, because there's no way, if she had given any other answer, if she had tried to say, yes, 30% less brain death would have occurred because of the 16-hour or 18-hour delay, depending on how you count it, I don't know what the basis for that would have been. So her answer was just a responsible answer, saying it's possible. But that's all you have. The possibility that things might have been better with more prompt medical care, of course, also entails that it's possible it wouldn't have been better, but that's not the proper question. It's not what exactly happened in this case, because a lot of times, and this is a good example, you can't quantify that. The proper question is, does waiting 16 hours to get medical care for someone who suffered a serious head injury, is that clearly insufficient to cause serious bodily injury? And then nobody asked that question. I would suggest that nobody qualified to answer it wouldn't say that it's clearly insufficient.
So I just want to be clear. Are you saying that there's no facts that would give rise to the instruction? Or are you saying that because of the weird interplay between these two statutes, 604 and cases of injury to a child with omission, that there's going to be large swaths of cases where concurrent causation is just not even applicable regardless of facts?
Yes. The primary argument is that this offense does not lend itself to a concurrent causation because she is responsible for the thing that she's trying to shift blame to. But as a fallback argument, and I think I should say probably both are going to have to be addressed. We got a general verdict, so and both alternative manner and means were pursued in tandem. So I don't know which theory the jury decided on. I can tell you there's legally sufficient evidence for both. The Court of Appeals has already found it on the failure to get medical care. But in order to wrap up the sum harm analysis, I think the state's gonna have to run the table here, just to make sure that if for some reason we lose on sufficiency on the first ground, we have an answer for the second question. And the second question is entirely fact-based, that there is just not the type of evidence you would need to get this instruction. Somebody needed to say in some language something close to, it really doesn't matter about the 16-hour delay. And 16-hour delay, it just does not cause serious bodily injury. It doesn't work that way. Which is
testimony to that the delay caused the injuries?
Yes. Really, all the testimony you need to look at is in volume 4, pages 88 or 89 to 102. And that's the back and forth you have. It's at the end of Dr. Patterson's testimony. And you wrap up, and the state says, so just to be clear here, if you get immediate medical care, she's going to have better condition. And the answer at first isn't yes or no. It's a lengthy explanation of the mechanism as to how you get brain death. It's ruptured blood vessels, it's brain swelling, cuts off blood flow to the brain, cuts off oxygen to the brain, results in blood.
I'm sorry, I'm a little bit confused. Is the omission here the failure to seek medical treatment or the failure to sufficiently intervene in the act that was occurring? Because at some point she said stop it, according to at least part of the testimony.
It's not exactly what you've described. It's two manners and means tried together instead of trying to divide it up and say this is the injury from shaking that you didn't stop and this is a separate injury that we can try to quantify from the delay. They put it together. And so part of it is you didn't get medical care in a timely manner. But the other part of it is failure to protect, but defense counsel tried to make it about you should have been in the room, you should have stopped this man at the moment. And that wasn't the state's theory of the case. The state's theory is that you have enough knowledge about what his history is and what he's done to this child already. Because, I mean, this is a 4-month-old who makes a popping noise when you pick her up. Medical care revealed that she already had broken ribs from 2 or 3 weeks prior, and mom knew about that, and the record shows mom knows about more. So the state's theory wasn't you need to step out of the kitchen and wrestle with this man and take your 4-month-old away from him. It's at some point in the last few weeks, you should have called CPS and gone to your mom's house with the kids. And then we're not here today. So those are what the state tried, but they did try them together, which is why I don't think you can just seize on one of these and wrap it up, because I think the evidence is sufficient for both. There's no indication that the jury didn't consider either of them. The argument centered on both of them. So, and that brings us back around again to the factual argument. Dr. Patterson's explanation of how this works is brain injury and swelling plus time equals brain death. So her testimony is that satisfies our burden for causation, that the 16-hour delay is going to contribute to the resulting injuries that the child is experiencing 2 o'clock Sunday afternoon when she finally gets to the hospital.
As a factual matter, was there any sort of vigorous dispute about the duty to act?
No, and in fact, in closing argument, defense counsel concedes that, looking at it, the jury says all of you would have jumped in front of a bus to save your kid. But, she didn't, and his argument basically was he's 6'4", he's a former Army Ranger, she's little, there's nothing she can do. And again, that shifts the focus away from the state's theory of the case, which that's what he should have been doing because there's no explanation for the rest of it. But he wanted to make it as much as possible. In that instant, she could have not stopped this from happening.
How much, I'm sorry to cut you off, counsel, but how much of your argument on the factual end is basically just sort of weighing the persuasiveness of the evidence that was presented versus questioning whether there was some evidence, which you seem to have just said in an argument, that the evidence wasn't going to be clearly insufficient. But you're also saying the evidence presented just isn't the kind of caliber evidence which suggests it was clearly insufficient. So how much are we re-weighing the persuasiveness of this evidence?
No, I want to be careful. It's not about weight and it's not about caliber. It's about type. Mm-hmm. Dr. Patterson, who you should have asked, mm-hmm. if you thought you could get this answer out of her.
Right.
The proper question would have been, does a 16-hour delay in seeking medical care for somebody with a serious head injury, is that clearly insufficient to cause serious bodily injury? That's the question to ask. The question that was asked, did she already have serious bodily injury as soon as Justin shook her? Yes, but that's immaterial. Can you tell me exactly how much mitigation there would have been? She says, no, it's possible, but I can't tell you that. Is there a greater or independent cause? Well, that's completely irrelevant because we're talking about concurrent cause. So the questions he asked.
But we're not trying to quantify, right? We're not trying to quantify the degree of cause. We're just trying to see if there's some piece of evidence that might raise the question of concurrent.
Is there any piece of evidence, with or without magic words, that is anything like delay in time is clearly insufficient to cause any additional injury? It is a non-factor. Somebody says that, he gets an instruction, or she gets an instruction, and maybe things would be different. But that isn't what the evidence, that runs contrary to everything that the doctor said. We proved causation, and there was just no evidence to suggest that a concurrent cause issue was here. And the last thing you want to do is give an instruction, especially one that's not necessarily friendly to read, to the jury when it's not an issue at the case.
Counsel? So there was testimony that the delay in treatment was caused by bringing the child here to Lubbock for medical care because there was a belief that there was better medical care for the child here in Lubbock than at their local hospital. And so if a jury took that into consideration as far as the omission aspect of it and focused instead on the other manner and means, and the law of parties was given as part of the jury instruction, wouldn't that cause some confusion for the jury? And clearly they were confused because they asked for the definition of causation, did they not?
Yes, and I think the defense counsel's argument was confusing. It was legally inaccurate, it wasn't challenged, and therefore it was confusing. And I will say that the evidence, I can't remember if anybody suggested that appellant went straight to Lubbock because she thought that's where I could get the best medical care. Her statements to investigators were, we didn't go local because we didn't want CPS to be involved with my husband. And the fact of the matter is, while there is evidence, and this is plain, that going to one of the local clinics would not have been able to do anything other than give oxygen, stabilize, and call a helicopter, at the outside, you're talking about 2 hours. So 10 o'clock Saturday night, this child could have been receiving surgery. They waited 16 hours to try to get medical care, and that was the problem. But yes, the jury asked for a causation instruction, but it wasn't applicable. Under basic causation, but for everything that appellant did, allowing her husband to be around the child after she knew what she knew about it, and not getting medical care, that is something that she is completely responsible for, and the instruction just isn't applicable.
Counsel, did you want to save some time for
I
rebuttal?
did, if there are no further questions.
Thank you.
May it please the court, counsel. My name is Paul Manser. I'm here on behalf of Danna Sear. First off, there really can't be any doubt that this case involves concurrent causes. And you read the indictment, it's in the indictment. Sear was charged with failure to protect. That's cause A. Then the indictment says Justin Sear injured this child and specified how he injured the child. That's cause B. The state's theory is that because of the nature of failure to protect, a crime of omission, all of the causal force of cause B gets attributed back to cause A. The problem with that, and the problem as I listen to opposing counsel's argument here, is it views the evidence in one way and doesn't ask if there's other ways to view the evidence. But also, is I think it casts too broad a net. Really what you need to look at is failure to protect, and then ask, what does that mean in the context of this case?
Well, counsel, could you explain to me how it is you could have a concurrent cause on this failure to connect or protect when really the injuries are severe, this one person did this? What other concurrent causation would there be in that type of case?
Well, I think you really look at what are we talking about when we say she failed, when she failed to protect. And then that would lead, and one thing, the indictment doesn't specify what act she should have taken or what act she failed to take. And so you're left to speculate about that within the confines of the case. And so you ask yourself these questions, and you hope the jury would ask the same questions. What's expected of her? What legally should she have done? And if you view the case maybe as the state presented it at trial, as they argued the evidence to the jury, maybe the state's right in that situation that it could have made a huge difference if she had done something, if she had called CPS, if she had removed the child, went to her mother's house. But you have other ways of looking at this evidence that maybe she didn't have notice that this was going on. Or maybe the notice was slight. Maybe she missed something. Maybe it doesn't rise to the level of recklessness. Maybe it doesn't get up to the level of criminal negligence. Maybe at some point, and we're talking about a family dynamic, we get to a point where she has enough information she should have acted.
I hear what you're saying, counsel, but it sounds like you're trying to say that there would be a causation based upon a lack of evidence. Like we're supposed to speculate about what this could be, and therefore that would give rise to some sort of idea of concurrent causation
I'm sorry.
instead of there being some evidence suggesting a concurrent causation in the failure to protect portion of the theory.
And I think when you start looking at the way defense counsel presented the case to the jury, and he was kind of hampered in his ability to argue the case, and he had to argue the case from the standpoint of beyond a reasonable doubt and whether it rose to the level of recklessness. What he wanted to do is argue concurrent causation given the facts. You know, is there some grain, is there a fact that could be presented to the jury that had she acted when that level tripped, you know, that she was acting recklessly, had she acted at that point in time, would it have mattered? And I think if you look at the evidence that the court, the Eastland court looked at, in their opinion, they said, well, the other two older children in the house saw Justin abuse the child, but mom was in the kitchen or mom was in the bedroom. There's no evidence that the children went to mom and said, hey, mom, this is going on. There's no evidence that
Well, it sounds like what you're describing is that just there's no evidence to show that she failed to protect, which isn't going to get you the concurrent cause instruction.
Right. But we get to a point where on the 29th, the child starts to cry. And she's in the kitchen and she says, I guess maybe pokes her head in the living room and says, hey, stop hurting that child. Maybe at that point we trip. And she should have stepped up and protected at that point in time. And we talked about, well, you know, what's expected of her. He's a 6'4" Army Ranger. Maybe she leaves. Maybe she calls the police. Maybe she calls CPS. Maybe she calls her mother, something like that. But at that point in time, would it have made a difference? Because the injuries had occurred. So we have both the failure to protect side of it and the failure to seek medical care.
Counsel, let me interject. So what about the argument that the state made that sort of hinted at the idea that the crime was letting him in the door voluntarily in the first place? How do you respond to that?
I'm sorry, can you repeat the question?
How do you respond to the, I guess, the implied argument of the state that the crime happened when she, knowing his past, she let him have access to the child? So disregarding the, you know, mom was in the kitchen or mom was elsewhere, just he shouldn't have even been in the house near the child in the first place. How do you
Right,
respond
and
to
that's
that?
the way the state argued the case to the jury. said the obligation to protect arose 2 weeks earlier when the ribs were broken because we had healing injuries. But, you know, there's other evidence that you look at. Maybe she didn't know, maybe she knew, maybe she didn't know. But the night before the injuries that gave rise to this case, Miss Sear was with her mother for a social event, and they talked about the child and the oddities of that she was making a popping sound. And nobody said, oh, well, these are broken ribs. And the child, there was evidence also that the child was not bothered by it. She was actually happy that night.
Counsel, in piggybacking on Judge McClure's point, kind of on the flip side, looking at this, would this not be a discrete, independent injury? And so we have to just look at this one injury and looking at the omission, or do we look at the totality of the child's situation regarding the omission as to this particular offense?
And maybe I'm not following the question. I think you do look at the totality of the evidence, but we have to do it within the confines of how we submit defensive instructions to the jury. We have to look at it in the light most favorable. So we are allowed to exclude evidence in determining whether there's some evidence that the jury could rationally conclude.
Let me see if I can clarify my question. So here you got the situation with the brain injury and you know, Justin allegedly harming the child on this particular day. So when we're looking at this case and looking at the omission aspect of it, do we take into account the evidence that this child had been abused before that day and that the mother knew that the child had been abused before this day? Or do we look just to this one incident regarding whether or not her action by omission, if we're looking at that, was the only thing that we look at? Do we look at all of the past history of abuse for the omission, or just this one incident for the omission?
And I think in this situation, the answer is no, you don't look at the past because we're supposed to look at it in the light most favorable. And I think you can rationally conclude under this case that you can exclude that evidence because we're talking about inferences. There's no evidence that directly said she was aware of past abuse. To get to that, you have to draw inferences. And whether the inferences are strong enough to give rise to legally sufficient evidence, the court didn't decide that, and I guess that's for a different day. But
I'd like to ask another question about 6.04a, and that is that if we agree with your argument, then does that mean that going forward, anytime someone is charged with a crime with criminal conduct by omission, are they automatically entitled then to a 6.04 instruction? Because after all, the fact that they're alleged to have committed the crime by not doing something means something else contributed to the injury that is the focus of the prosecution.
yeah, and I think that, you know, that's the first part of the inquiry, and that's how I started my argument. You know, there are two causes.
So it's inherent is my point. And that's what I'm wondering is, if we agree with your argument, then does that mean that concurrent causation, if requested as an instruction, needs to be given, a matter of law, in every one of these omission cases going forward?
That's a really interesting question, Judge. You know, when I first approached this, I thought it was a defense because courts treat it like a defense.
Right.
But it never really dawned on me until I got here and started working on this, that why do we treat it like a defense? Why don't we treat it like an element of the crime that needs to be defined for the jury and applied in cases where you ask that initial question? Is there more than one cause? If the answer is yes, get the instruction. I don't know. I mean, the state begins their brief by saying it's not a defense. It's anti-defensive.
Right.
But all the courts, including this court, have treated it like a defense and require the inquiry to have some evidence from any source, when viewed in the light most favorable, giving rise to that last clause under unless.
Right, right.
So,
Counsel,
So you don't know the answer then, is that, I mean.
I mean, I think it would be for this court to answer that question.
yeah, we don't know
whether-
the answer to that either. That's why we're here.
Well, that's why y'all are elected to make these decisions. So.
I wanted to ask you something similar to what I asked the state prosecuting attorney on this. Is it possible for us to resolve this case, though, without getting all these big heady ideas and just say, on the second theory of liability, namely the failure to seek medical help in a timely fashion, that there's some evidence in the record that gives rise to a concurrent causation, and we can just say, well, there's a lot of good arguments about the first failure to protect, but we don't need to reach them because at the very least, they were entitled based upon this one theory.
I think that would be fair. I think there's many ways that the court can.
Well, could you explain to me what that argument is then?
Okay. Yeah, I disagree with the state. I mean, they want affirmative evidence, and I'm racking my brain. What is affirmative evidence? And and opposing counsel came up here and defined it. We've got to have, I guess, medical testimony saying that it wouldn't have gotten worse, or something like that. And that's not the standard. The standard is, because inferences count. And this case is
Can you speak
chocked.
up, counsel? I'm sorry.
Yeah, yeah.
Can you speak up?
I'm sorry. This case is chocked full of circumstantial evidence, and inferences can be drawn in a number of different directions. Look at all the medical testimony. Read all of Dr. Patterson's testimony. Read all of Dr. Cocking's testimony. This is a shaken baby case, so it brings in a doctrine called shaken baby syndrome, where you have a triad of factors, and it wasn't really, the science wasn't really challenged in this case, so we just have basically the theory presented to the jury, but it causes severe brain trauma at the time it happens. It may progressively get worse, but the trauma is there. Now, there's a case cited both by the state and my brief called Payton. In that case, the question was, all these cases are tragic, but the child ultimately died. And so the question there was, had the grandfather taken the child to the hospital, they could have lessened the brain swelling or relieved that and saved the child's life. But the brain trauma still would have been there. So in this case, we have serious brain trauma, and we have testimony from Dr. Patterson that says no matter what, that brain trauma was going to be there, it was caused by Justin, and it was severe. I think from that evidence, it's possible that if we'd gotten to the hospital a little bit earlier, we could have lessened that or mitigated it without defining it. I think the jury was very, very much could have inferred that it wouldn't have mattered. In other words, it was clearly insufficient.
Yeah, I guess just following up on what Judge Newell said, just giving her the benefit of the doubt that she intervened in whatever he was doing to her. And so it's not a crime by omission. She stopped whatever act was taking place. It seems that the facts lead to the conclusion that they intentionally avoided taking her to the closest medical care facility for their own reasons.
And that's one way of looking at the evidence.
And so how do you get around that aspect of the case?
Look at the other evidence that was presented to the jury. There was some evidence there that Justin said, I didn't want to go to Denver City because I didn't want to get
before you go any
CPS.
further, let me just ask you, was there any evidence presented that she just had no idea that the baby had some sort of a head trauma? Because those tend to sometimes not manifest themselves as others.
Well, I think when she saw the child and the condition of the child having a seizure, she says, look, we got to go to the hospital. And Justin was like, no, I don't want to go to the hospital. I want to call my sister. She's a nurse. She's a medical professional. They call her. She says, well, in this situation, why don't you give the child some Tylenol? They do. 20 minutes later, the child
But
gets
she also
better.
told her to go immediately to the clinic that was 6 miles away, too. So it wasn't just Tylenol, she'll be fine.
Right. And I'm sorry. I I don't recall that part of it, but I do recall the Tylenol. I guess the point I'm making is they followed part of her advice. The child got better and didn't have another seizure until the next morning. So once again, I'm not looking at the evidence selectively. I'm just applying the standard in the light most favorable to giving an instruction. And could rational conclusions be drawn from that particular way of looking at the evidence?
But just simply considering what you just said, didn't have another seizure until the next day. Now we've got 2 seizures, and yet we're
Right.
going to go some way far, far away to get medical attention.
Yeah, I don't know that White Rock to Denver City is like 5 miles. White Rock to Lubbock is 70, 75 miles. You know, whether and once again, I go back to the evidence. You know, was that a good decision? Maybe not. I mean, no, it wasn't. But, I mean, had they taken the child to Denver City, there would have been some time lapse before they could get the helicopter there. Maybe and defense counsel spent a lot of time talking about and talked to all these hospitals and brought professionals from each hospital. It's like, what could you have done had the child been brought to this hospital? And the answer again and again and again was just basically stabilize and wait for the helicopter. So I think we have to consider that evidence as well. I'm sorry, Judge. I've got some more stuff in my notes, but I don't really know that I have anything else to say.
Let me ask you one question
Good.
before you quit. I think you said just a minute ago that the state relied on expert testimony that it was possible that the injuries may have been lessened had appellant sought immediate medical attention. And then on cross-examination, if I remember correctly, the expert admitted that he couldn't say it was or she couldn't say it was probable, and she couldn't say it was above 50%. So how, and I'm thinking back about how many times I've heard prosecutors say anything's possible. Aliens could have done it. That's possible. So don't listen to possible. So how is this affirmative evidence rather than just no evidence? When the state says it's merely possible.
And I guess, you know, you get right back to what Dr. Patterson had said initially, that the brain trauma was inflicted and it was serious, and it happened previous to, you know, any decision to go to before that, going to the hospital wouldn't have changed that. That it was going to be serious. Whether it could be lessened or mitigated, she was, you know, maybe. So that's the way I read it. I don't know if I answered your question. I'm sorry, my red light just came on.
So do you think when a prosecutor or when an expert says, well, maybe it would have been mitigating the injuries, maybe, possibly, that rather than that being an omission, that it's the other way, that's actually saying that it's likely that there would have been no mitigation. Yeah,
I'm
that's
sorry. Yeah, I think it supports what we're saying is, you know, it just there wasn't any additional. It was, I mean, and I go back to Wright and Payton. It doesn't really talk about, you know, we have this amount of injury here. Had we gone to the hospital, we have, or because we didn't go to the hospital, we have this amount of injury. Really, it says serious bodily injury, and did this aggravate that serious bodily injury? I think what you're saying is it supports the conclusion that it did not aggravate.
That actually raises a question I wanted to ask. His question sort of dovetail into this. Is there any evidence that if they'd gotten to the hospital sooner, that it would have resulted in, like, it would have not resulted in the aggravated injury, would have resulted in a smaller degree, such a smaller degree of injury that it might have changed, say, the punishment range or something like that? Like made it a different or a lesser offense or anything like that?
No, no. I think the evidence was that it was going to be serious no matter what.
Okay.
So, and I mean, I think I would look at Peyton where where the difference was between life and death. Here we just say it's serious, and it would have been serious any way you go about it.
This child did not die, is that correct?
No. So,
Okay, thank you, counsel.
thank you.
May it please the court. What Judge Walker was just asking about really is the case. On the second point, which Judge Newell's edification, if the state loses on the second point, the case just ends. Otherwise, we would need to win on both points and send it back for a further sufficiency review. But on what Judge Walker said is right.
If you went on the second point, then it's moot. If the first point is moot, right?
Only because there was a request for the instruction, and under some harm analysis, I can't tell you that they focused only on one theory or the other. So I don't think you're going to be able to avoid finding there was some harm if she was entitled to the instruction.
I mean, I can kind of get why they might have it should have been given in the first part as to whether or not her act was by omission. So I'm a little bit confused about why the court didn't give the charge then, but I haven't heard anything so far that would suggest that waiting 16 hours with a head injury would not be omission if it was obvious that she had some sort of trauma.
Right, and this is part of it. If there had been some testimony that we went straight to Lubbock because we knew this was serious injury and we didn't want to go somewhere and wait for a helicopter, that's great. You do that 8 o'clock Saturday night. You don't do that the next day. And I do want to say, we talked a lot about sufficiency, but sufficiency on the failure to get care was decided below in the state's favor and hasn't been appealed. Sufficiency for the recklessness to protect hasn't been decided yet. I'm confident the way it's going to go, and I'll talk about it if you want to, but under our theory, that should be fine. But again, Judge Walker's point is correct on whether or not it's applicable on the failure to get medical care. Having testimony that it possibly could have helped is nothing like testimony that it clearly wouldn't have made a difference. There's no level of inference, there's no role of the jury that can close that gap. There is nothing like the 16-hour delay in care cannot cause serious bodily injury, just as a matter of science, as a matter of anything. If somebody had said something like that, then the instruction should have been given, and it just isn't there. All of the evidence is that swelling plus time equals more injury, more brain death, and that's exactly what we had in this case.
Counsel, you're focusing on taking care of this on Saturday evening, but it's my understanding, and certainly correct me if I'm wrong, that the evidence was that when, first of all, appellant did not see Justin do whatever act he did to the child to cause the injuries. And when she saw that there were symptoms, they called Justin's mother, who was, I believe, a nurse, and asked what to do. And the response was to give her Tylenol and watch her. And so at that time, they took what could be considered reasonable steps to seek medical care by talking to a nurse and following the nurse's instructions. And it wasn't until the next day that she had the spasms that then or the seizures, that when they then talked to the mom again, the nurse again, that she said, take her to get medical treatment immediately.
Well, as a preliminary matter, it sounds like we're relitigating the sufficiency, and that's already been done.
No, I'm going to, we're talking about the ultimate injury here and the ultimate, cause, because we're talking about omission. So if you're talking about omission, it's not the sufficiency, it's the concurrent cause aspect, so that I'm concerned about here. So if you can address that, that would be great.
If the question is whether or not any additional harm would have accumulated, that's not the point. 604A makes it so you don't even ask that question. I think the evidence from Dr. Patterson makes it clear that more time equals more brain death, which is more serious bodily injury. But the question isn't whether or not the SBI threshold was achieved Saturday night and nothing else happened. At 2 o'clock Tuesday, or 2 o'clock Sunday, a child presents at the hospital with serious bodily injury. That's the injury that we prosecuted. You go back to say, what are the causes of this? It's shaking plus time. And when that's the theory of the case, and that's factually what the evidence shows in terms of causation, we just don't have a conversation about what percentage of injury was caused by which manner and means. She's responsible for all of it. That's just how 604A is designed to work, by design. And unless somebody says what she did at the back half, which was failure to get care, was clearly insufficient, could never cause any additional SBI, or could never have caused the SBI that resulted. If somebody says that, you get an instruction. If nobody says anything like that, there isn't an instruction. All of the evidence points to unprotected shaking plus time equals the injuries you have on 2 o'clock Sunday. That's just how the law should work.
Let me ask you one more question. Okay, when this expert testified that she couldn't determine whether the chance of mitigation was probable, isn't that a strong implication that it would be unlikely that immediate medical attention would have mitigated the injury?
I think you can draw the inference that maybe nothing would have changed, but that's not the inquiry under 604A. It's not whether in this case this is actually what happened. It's whether or not you being responsible and being a but-for cause, this other aspect that we're looking at is clearly incapable of it.
But isn't it some evidence
It
that immediate medical
would be some evidence that just like,
would have not have mitigated?
yes, I think you can parse that out. I should add that the indictment included serious mental impairment. That dropped out by the time of the jury charge. So part of the conversation with Dr. Patterson is she would still have some sufficient mental impairment. And if someone had asked her a more pointed question, I don't think there's any way, she certainly would not have, and I don't know any expert could have said how many more words this girl would know at age 5 if she had gotten more prompt medical attention, or would she have been able to walk before age 5, which is what the evidence shows. So it is some evidence that maybe in this case there wasn't additional injury, but again, that's not the question. The question is an abstract inquiry. Can waiting 16 hours after a serious brain injury, is that clearly insufficient to cause serious bodily injury? And nobody would have said that because nobody can.
Yeah.
Do you agree with Mr. Mansour that, that the courts seem to treat 6.04 almost like it's a defense? And if so, or if not, what do you think about that? Do you think that how should it be treated? More like a generally applicable theory of law, of liability, or like a defense?
I think the first half of 604A is a general instruction explaining that we use a but-for test like most other jurisdictions. And I think that's something that can be given in any case because it's easily satisfied. The back half, dealing with concurrent cause, requires specific information because as we're all here today, I mean, we're about 50 years into this penal code and we still haven't figured out exactly how this works. Now, as a matter of fact, defendants normally ask for it because they think it benefits them. But I think all of this court's cases have said that he wasn't entitled to it for whatever reason, because it is a very difficult hill to climb. And this case pushes that, but it's consistent with all these cases. Like, give us some evidence that what you did was, in the abstract, clearly insufficient to have caused this, and you'll have gotten your instruction or your lesser included offense. But absent that, this is the way the law is supposed to work. But for what you did, this happened, and there's no evidence that you didn't cause it.
Thanks.
Thank you, counsel.
Thank you.
The case is submitted, and the court will stand in recess for 15 minutes.